The West Bengal Legislative Assembly on September 3rd unanimously passed an anti-rape bill in the aftermath of the brutal rape and murder of a postgraduate trainee doctor at the state-run Aparajita Medical College and Hospital in Kolkata. The bill known as the Aparajita Women and Child West Bengal Criminal Laws Amendment Bill 2024 prescribes the death penalty for rape and also imposes a life sentence without parole on those convicted. So what are the key provisions of the bill and what are the concerns flagged by experts? Let's find out. Under the Bharatiya Nyaya Sanhita or the BNS, the death penalty is reserved only for cases wherein there is commission of rape involving a girl under 12 years of age or there is commission of gang rape involving a girl under 16 years of age. For other rape-related offences under both the BNS and the Protection of Children from Sexual Offences Act or the POCSO, the maximum penalty imposed is life imprisonment. However, this bill prescribes a compulsory death penalty for the offence of committing rape and inflicting injury that results in the death of the victim or causes her to be in a vegetative state. This is a first of its kind law since no other offence in any other law has a mandatory death sentence. The bill also proposes that investigations into cases of rape and sexual assault of children must be concluded within 21 days of filing the FIR. This is a substantial reduction from the previous 2-month deadline. Extensions are allowed but only with the written justification of a senior police officer. It also requires courts to conclude trials for rape and acid attack cases within a period of 30 days from the date the charge sheet is filed, contrary to the existing time period of 2 months. When it comes to repeat offenders, the legislation proposes life imprisonment with the possibility of a death penalty if the circumstances of the case warrant it. The bill also proposes the establishment of special courts and an Aparajita task force. The special courts will ensure expeditious completion of inquiry and trial and will be presided over by a person not below the rank of a sessions judge or additional sessions judge in the state with the concurrence of the Calcutta High Court. Whereas the task force will be established at the district level led by a deputy superintendent of police to investigate specified offences. The bill further stipulates that investigations being done by the task force will be carried out by a female police officer as far as possible. Anybody who is not willing to provide assistance or intentionally omits to provide assistance to this task force will be punished with imprisonment of 6 months or a penalty of ₹5,000 will be imposed upon them or both. Now, have similar bills been passed in other states? Yes. In the past, both Maharashtra and Andhra Pradesh have passed similar laws. In Andhra Pradesh, the bill was named as the Andhra Pradesh Disha Bill of 2019 and in Maharashtra it was named as the Shakti Criminal Laws Maharashtra Amendment Bill of 2020. The Disha Bill also introduced the death penalty as punishment for the crimes of rape, including against a minor below 16 years of age, gang rape and for repeat offenders. Similarly, the Shakti Bill also introduced the death penalty in rape cases and for heinous acid attack cases where adequate conclusive evidence is there and the circumstances warrant exemplary punishment. Both bills had also proposed shortened timelines for the conduct of investigation as well as trial. Like the Bengal bill, the Disha bill had also proposed the establishment of special police teams and exclusive special courts for trying crimes against women. However, both bills are currently awaiting the assent of the President. This is because under Article 254 of the Constitution, if a state law on a subject falls in the concurrent list and is in conflict with the central law, then the President's approval is needed for it to be made effective. Criminal law is part of the concurrent list, which means both the centre as well as the states can legislate upon it. Now let's look at some of the concerns flagged by experts. Extensive studies conducted by National Law University Delhi's Project 39A have revealed that there is very little evidence to suggest that death penalty acts as an effective deterrent to crimes, with data indicating that most of the death penalty cases are actually overturned or commuted on appeal. In the past 10 years, only 5 persons have been executed by the death penalty in India after being convicted of crimes. Data from Project 39A's 2023 annual statistics on the death penalty show that 561 prisoners were on death row at the end of 2023, indicating a burgeoning death penalty crisis in India. The Justice G.S. Verma Committee, whose recommendations led to crucial amendments to the criminal law back in 2013, was also not inclined to recommend the death penalty for rape, even in the rarest of rare cases. It was of the opinion that death penalty would be a regressive step in the field of sentencing and reformation. Thank you for watching. For more such videos, please subscribe to The Hindu.